The courtroom was cold the way government buildings always are. Not the kind that makes you shiver, the kind that presses against your chest and just stays there, reminding you that the room does not care. My name is Naomi. I am 34 years old. That Tuesday morning, I sat 2 rows behind my husband, Damien, and watched the back of his head. His posture was easy, almost proud, the comfort of a man who believes he has already won. His lawyer, a sharp-eyed man named Batten, kept leaning over to whisper things that made Damien nod. Confident. Slow nods. The nods of someone collecting a prize. I had not spoken to Damien in 11 days. Not since the morning I walked out of the house on Caldwell Drive with a single box of documents under my arm and no goodbye. I kept my hands folded in my lap. My attorney, Priya, sat beside me. She had a yellow notepad, a pen, and the kind of face that gave nothing away. The probate judge, the Honorable Walter O. Say, adjusted his glasses and opened the docket. I felt Priya's hand brush my elbow. "He's going to read yours first," she whispered. I already knew. That was the whole point. I had filed before Damien ever woke up. It started at a dinner table. Not mine. His mother's. It was a Sunday evening in late October, 11 months before the courtroom. Damien's family filled every chair around Miriam's long oak table. His uncles, cousins, his Aunt Bee who always smelled faintly of cedar and old perfume. I had cooked the roast myself and brought the wine. We were still eating when Damien stood up. I thought it was about his business. He had been talking about expansion, new investors, a second city. I set down my fork and smiled the way wives smile when they expect to be proud. He looked around the table. He did not look at me. "I'm expecting a child," he said. "With someone else. I want the family to know I intend to protect that child's future, including through the estate." The table went quiet. I did not move. I did not make a sound. I felt the heat leave my face like a tide pulling back from shore. He sat down calmly, as if he had described the weather. Aunt Bee looked at me. I looked at my plate. The roast I had cooked was still steaming. Nobody touched it after that. Damien's father, Bernard Archer, had died 14 months before that dinner. He was a careful man who built a modest but solid estate over 4 decades, a house on Pembridge Road, a rental property in the valley, a bond portfolio, a small commercial unit on the east side of the city. When Bernard got sick, a slow illness that lasted 18 months, it was me who stayed. Damien traveled for work. His sister Nora lived across the country. So I became Bernard's person. I drove him to appointments. I organized his medications. I sorted the decades of paperwork in his study, the folders and envelopes quietly accumulating since the 1980s. Bernard noticed. He was the kind of man who noticed everything and said very little. One afternoon, on a good day, he looked at me directly. "You're the one I trust," he said. "You understand what things are worth." He didn't mean money. He meant time. Care. The quiet labor of showing up without an audience. I filed every document carefully. I knew those records better than anyone, including better than Damien. That knowledge, sitting in labeled folders in my home office, was what Damien had completely forgotten about me. The affair had started before Bernard died. I found out 3 weeks after the funeral. A message. Not even hidden well. A thread on Damien's tablet, left open on the kitchen counter, which told me how little he feared me. Her name was Colette. 29 years old. A photo on her page showed her laughing on a boat somewhere warm. She looked like someone who had never had to file paperwork for anyone. I read the full thread. All of it. It had been going on for over a year. Through Bernard's illness. Through the hospice visits. Through the funeral where I stood beside Damien and held his arm while he wept. I set the tablet down. Walked to the window. Stood there a long time. He came into the kitchen 20 minutes later, picked up the tablet, and left without noticing anything different. I said nothing that day. But something shifted. Not dramatically. Not with tears. It shifted the way a locked door shifts when someone finally finds the right key. From that moment, I began paying close attention to everything. Especially the estate documents I had so carefully organized over all those months beside Bernard. People always ask why I didn't confront him immediately. Why I kept going to family dinners and sitting beside him at church like nothing had changed. They think silence means surrender. It always looks that way from the outside. What 18 months of managing a dying man's affairs had taught me is that patience is not weakness. Patience is what you practice when you know that timing matters more than noise. Damien was built for scenes. He was good at them. He knew how to make your tears look like instability and your anger look like irrationality. So I gave him neither. I went to sleep each night beside him and said nothing. I watched what files he accessed on his laptop. I noted what calls he took in the car with the windows up. And at night, after he slept, I returned to my office. I reread every document connected to Bernard's estate. Every amendment. Every addendum. Every letter. I was looking for what had changed since Bernard passed. What I found made my hands go still on the keyboard. The estate had been quietly redirected. The paperwork existed. And in that paperwork was something Damien had missed. A clause that would change everything. The trust amendment was drafted 4 months after Bernard's death. It was buried inside a folder I had not accessed in weeks. A clean, formal legal document. But something about it made my stomach tighten the moment I reached the first page. It redirected a significant portion of Bernard's estate into a new trust. The listed beneficiary was the unborn child of Damien Archer and Colette Fairfax. My name was nowhere in it. I turned to the signature page. The amendment required spousal notification before execution. A clause Bernard's original estate attorney had insisted upon, a safeguard designed to ensure marital assets could not be redirected without both parties being aware. There was a signature line for me. It was blank. Someone had filed this amendment without my knowledge. Without my signature. I sat back in my chair. The house was still. Only the hum of the refrigerator from down the hall. I did not panic. Panic is loud and expensive. Instead, I opened a new folder on my desktop and named it Archer Estate. Full record. I began copying every document I had, one by one. By 3 in the morning, I had a complete, organized archive of everything. The weeks after the dinner announcement were strange. The family didn't know how to act around me. Damien's cousin Petra kept calling with careful pity in her voice. His uncle Noel stopped making eye contact. Aunt Bee sent a fruit basket with no note, which meant she was horrified but had no words for it. Damien, for his part, seemed almost relieved. He became warmer, more cheerful. He came home later. He stopped asking about my day. The most dangerous thing he did was start talking about me. Not openly. Quietly. He told Cousin Patrick that I had been struggling emotionally since Bernard died. He mentioned to the family's financial advisor, a man named Stuart, that I had been not quite myself. He used words like fragile in ways that sounded caring but were building something else entirely. A picture. A narrative. One where I would later appear unstable if I ever challenged anything. But Stuart had known Bernard for 15 years. He was a careful man. He noticed that the woman being described as fragile was the same one who had kept Bernard's affairs in perfect order through the hardest months of his life. Stuart began asking his own quiet questions. He would matter later. More than Damien ever imagined. I found the letter on a Wednesday afternoon, helping Miriam clear the last items from Bernard's study. It was tucked in the back of his desk drawer, inside a brown envelope I had missed on my first pass. It was handwritten, 4 pages in Bernard's careful script, and dated, signed, and witnessed by his neighbor Dorothea, a retired schoolteacher 2 houses down. He called it a letter of intent. It wasn't a binding legal document. But it was real and it was clear. Bernard wrote that his estate was designed to remain a marital asset. It was built for the stability and security of his son's marriage. Any changes were to be discussed openly, with all parties present. He wrote one line I had to read twice. If there is ever a dispute, let the record show what this family was built on, and who kept it standing when it was hardest to do so. I folded the letter carefully and slid it into a protective sleeve. Then I drove directly to Priya's office. I had found what I needed. Now I had to understand what to do with it before anyone realized I had it. Priya had been recommended by Dorothea, whose daughter had navigated a complicated divorce years ago. She is not loud, Dorothea told me, but she wins. I sat across from Priya on a Thursday morning and laid everything on her desk. The trust amendment. The spousal notification clause. The blank signature line. The full estate archive. And Bernard's letter. Priya read without interrupting. When she finished, she was quiet. You understand what this means, she said. The amendment is procedurally flawed, I said. The notification clause was never honored. That's the foundation of a challenge, she said. But timing matters here. If Damien files to validate the amendment before you file a challenge, the court addresses his filing first. Your challenge becomes a response, not a primary claim. The judge reads his version of events before yours. She looked at me steadily. You need to file before him. Before he realizes what he missed. I asked her how long we had. She checked the court calendar and said one word, days. I drove home that evening and said nothing to Damien. I helped him set the table for dinner. I passed him the bread. I smiled when he made a small joke. That night, I reviewed everything one final time. 2 weeks before the court date, Damien held a gathering. He called it a family celebration. He rented a private room at a restaurant on the north side of the city and invited cousins, his uncle, his mother Miriam, and several friends. He added me to the group message thread, as if I were just another contact in his phone. I went. I wore a dark navy dress I had bought for Bernard's retirement dinner years ago. I sat at the end of the table and listened to Damien toast new beginnings and legacy and the future. Nobody quite knew what to say to me. I smiled at the appropriate moments. I thanked the waiter. I had water, and a plate of food I mostly left untouched. Damien watched me across the table, trying to read something in my face. Distress, maybe, or a quiet plea. Something he could respond to. I gave him nothing. At 9:15, I said my goodbyes. I told Miriam it had been a long week. She held my hand a moment longer than necessary, her eyes wet. I drove home, changed out of the navy dress. And at 11:40 p.m., I submitted the filing. Filing probate documents at midnight sounds dramatic. It isn't. It's a laptop, a secure court portal, a carefully scanned PDF, and a credit card for the filing fee. But the timestamp matters enormously. Under probate rules in our jurisdiction, the court addresses petitions in order of receipt. If I filed before Damien, my filing would be read first. I would not be a respondent. I would be the primary claimant. My challenge was specific. It cited the spousal notification clause by section. It attached the original trust to show the clause clearly. It attached the amendment to show the blank signature line. It included a sworn statement from Priya outlining the procedural failure. At the end, it attached Bernard's letter of intent, with Dorothea's witnessing signature. I pressed submit at 11:47 p.m. The confirmation email arrived 4 minutes later. Filing accepted. Timestamp recorded. I closed my laptop. Made tea. Sat in the quiet. Damien was asleep upstairs. He had no idea that the order of everything, every conversation, every claim, every version of the story that would be told in that courtroom, had just been decided. For the first time in months, I felt completely calm. Damien filed his petition at 10:14 the following morning. I know the timestamp because Priya called within the hour. He filed, she said. Petition to validate the amendment, as expected. His attorney is Batten. He's good, but he didn't check the docket before filing. He had no idea you'd already moved. I asked what happened when they realized. Batten's assistant called our office asking whether there had been a system error. I told her there was no error. Our filing was received at 11:47 the previous night. A pause on the line. How is Damien? I asked. I imagine he's not having a pleasant morning. He assumed the amendment was solid. He assumed you had no idea it even existed. He assumed he was the one holding all the cards. He forgot, I said quietly. What did he forget? That I'm the one who organized those files. Every one of them. For years. Priya was quiet for a moment, letting that sit. The court date stands. 3 weeks. Be ready. I told her I had been ready for a long time. I hung up and made coffee. Outside, it was an ordinary morning. Birds on the wire. Neighbors walking dogs. The world completely unaware. 6 days after Damien filed, a settlement offer arrived. It came through Batten's office on formal letterhead, addressed to Priya. The language was careful. The offer was not. It proposed a one-time payment of less than 12% of the estate's total value in exchange for my withdrawal of the challenge and my release of any further claims. A note in the Additional Terms section required me to sign a non-disclosure agreement preventing any discussion of the estate structure with third parties. Priya forwarded it with one line, "Your call." I read it twice. I thought about the hours I had spent driving Bernard to appointments and sorting his papers late into the night. I thought about the blank signature line. I thought about his letter. Let the record show who kept it standing. I called Priya. "Tell them no," I said. "Any message? Just no." Damien's team sent a revised offer 4 days later. Slightly improved, still inadequate, still attached to the non-disclosure demand. I didn't reply to the second one. Priya sent a 2-sentence acknowledgement and nothing further. The offer expired. Batten knew by then that I was not going to be quietly settled into a corner. Stuart, the family's financial advisor, came to Priya's office on a Tuesday afternoon. He brought a folder. He had known Bernard for 15 years. He was a precise, careful man who did not make unnecessary statements. He sat across from us and spoke slowly. In the final months of Bernard's illness, Damien had approached him twice about restructuring the trust. The first time, Stuart had suggested Bernard be included in any discussion. Damien had declined, saying Bernard was too tired for the details. The second time, Damien brought amendment documents for Stuart to review without Bernard present. Stuart had grown uncomfortable. He had not signed anything. But he had not reported it either, a fact he acknowledged with visible regret. He had also been present when Bernard made a specific remark during their last meeting together. Bernard had said quietly, "I hope nobody is in a hurry to do anything while I'm still here to see it." Stuart believed that remark was directed at the amendment conversations he had witnessed. Priya took down everything. She listed Stuart as a witness. When he left, she looked at me. "He's your strongest piece," she said. "He almost didn't come," I said. "But he did. That matters." The morning of the hearing, I arrived at the courthouse early. I wore a simple charcoal suit. The only jewelry I had on was a small pin that had belonged to Bernard's late wife. Miriam had given it to me on our first Christmas together as a family. I had never worn it before. I wore it that morning because I wanted something honest on my body in that room. Priya was already inside, reviewing her notes. She looked up when I entered, studied my face briefly, and nodded once. I sat down. I folded my hands. Damien arrived 12 minutes later with Batten. He saw me immediately. His step slowed. Barely noticeable. He recovered, straightened his jacket, and moved to his table with practiced ease. He did not look at me again. The room filled slowly. Relatives with no legal standing, drawn by the gravity of it. Stuart sat in the back row. Nora, Damien's sister, sat along the wall. She had flown in 2 days ago and called me the night before. "I'll be there," she had said. Nothing more. I had not asked her whose side she was on. Some things don't need to be asked. Judge Osei opened the docket and turned to my filing. The moment he announced he would address the challenge first, I heard Batten shift in his chair, the small creak of leather in a quiet room. The judge read in silence for several minutes. He asked Priya one clarifying question about the notification clause. She answered in 2 sentences. Then he turned to the trust amendment itself. He studied the signature page. He read the clause requiring spousal notification. He looked at the blank signature line for a long moment. He removed his glasses. "Counsel," he said, addressing Batten, "can you help me understand the basis for the execution of this amendment given that the notification requirement was clearly not fulfilled?" Batten stood. He offered an explanation, that Damien had understood the provision to be advisory rather than mandatory. The judge looked at him steadily. "The language in this clause is not advisory," Judge Osei said. "The word used is required. That is not ambiguous." He set down the document. "This amendment carries a procedural defect that cannot be overlooked. I am noting it formally in the record." On my left, Priya made a single small mark on her notepad. Bernard's letter of intent was entered into evidence as Exhibit 7. The judge read it fully. No one spoke while he did. When he finished, he set it down carefully and looked at the room. "This document is not legally binding in the traditional sense," he said. "But it is admissible as evidence of the original intent behind the estate structure. Courts consider such documents when assessing whether changes align with or contradict the Creator's wishes." He paused. "The letter is clear. This estate was designed to serve the stability of the marital unit. The amendment redirects a substantial portion of those assets to a beneficiary outside that unit, without required spousal notification, and in a manner that contradicts the testator's expressed intent. He looked at both attorneys. I will take a brief recess before issuing findings. I want to review the witness affidavit from the financial advisor on record. He stood. The clerk called the room to rise. I looked straight ahead. I did not turn toward Damien. I had spent 14 months building this moment, with silence, patience, and every document I had touched and preserved when no one thought it mattered. The judge had just told the room what the record looked like. During the recess, I stepped into the corridor. I stood near the window at the end of the hall, looking down at the city, gray and steady, ordinary in the way cities are when something inside you is not. I heard footsteps behind me. Batten came around the corner first, phone to his ear. He passed without acknowledgement. Then Damien appeared. He stopped a few feet away. He looked older than he had at that dinner table in October. The easy confidence from earlier had developed visible cracks. His jaw was tight. His eyes had lost their certainty. He looked at me the way a person looks at something they thought they understood and suddenly don't. You knew, he said. The whole time. I said nothing. You had all of it. The documents. The letter. You just... He stopped. Why didn't you say something? Before all this. Under whose terms? I said quietly. At whose table? He had no answer. I never stopped caring for that estate, I said. Even after I found out about Colette. I kept every record. I kept them correct. He stared at me. That's what you never understood about me, I said. I turned and walked back toward the courtroom. Judge Osei returned to the bench 17 minutes later. He settled his papers, adjusted his glasses, and looked at the room with the calm of a man whose decision had already been made. This court has reviewed the challenge to the trust amendment in full, he began. Having considered the procedural record, the witness affidavit, and the letter of intent submitted into evidence, this court finds as follows. A brief pause. The amendment in question was executed without the spousal notification required by the original trust instrument. This is not a technical defect. It is a substantive one. The clause exists specifically to protect marital interests in estate assets. Its omission cannot be treated as inconsequential. Batten sat completely still. Furthermore, the letter of intent establishes a clear, documented expression of the testator's wishes. The amendment contradicts those wishes in both structure and spirit. He looked up. This court rules the trust amendment invalid. The estate reverts to the structure established in the original trust instrument executed by Bernard Archer. Somewhere behind me, a sharp intake of breath. I kept my hands folded. I kept my eyes on the judge. It was over. It had ended exactly where it needed to, in the record, in the truth, with every document accounted for. The ruling rippled outward faster than I expected. Within hours, the judge had added a separate notation to the formal record. It flagged the circumstances under which the amendment was drafted, specifically the timing relative to Bernard's illness and the financial advisor's testimony about discussions held without the estate's creator present. The notation referred the matter to the State Bar's ethics review body. That referral was what Damien had not prepared for. He had walked into the courtroom ready to lose the procedural argument. His attorneys had likely warned him it was possible. But an ethics referral, a formal suggestion that he had pressured a terminally ill man to alter his estate, carried a different weight entirely. It was not a criminal charge. But it was a formal flag in a permanent record. It would follow him into every professional room afterward. Damien's consulting firm ran on trust. On reputation. On other people believing he was someone who could be given responsibility over their money and plans. The referral made that significantly harder. He was still standing when the room cleared. His posture was correct, his face composed. But the ground beneath him was different now. Something solid had been removed, and he would only understand the full weight of that absence later. Stewart waited for me in the corridor. He stood near the window where Damien had stopped me during the recess. He looked tired but not regretful. He held his folder under his arm the way he always did, like something he had been meaning to set down for a long time and had finally found a place for. I should have spoken sooner, he said. You came when it mattered, I told him. That counts. He nodded slowly. Bernard trusted you, he said. He told me once, when you two were going through the bond records together. He said, that woman understands what this is for. He didn't mean the money. He meant the whole thing. The family. The integrity of it. He paused. He'd be glad today went the way it did. I thanked him. He shook my hand. Firmly, the way careful people do when something serious has been resolved. Then he walked away down the corridor, measured steps, folder still under his arm. Nora appeared beside me a moment later. She said nothing at first. She just stood there, looking out the window. After a while she asked, "What do you need?" "Time," I said. "Just time." In the weeks after the ruling, the family rearranged itself. Miriam called first, 3 days later. Her voice was careful, navigating guilt and love at the same time. She said she hadn't known about the amendment. She hadn't known the extent of it. I believed her. Bernard had always protected her from the harder details. We talked for almost an hour. About Bernard, about the estate, about what came next. She cried twice. I stayed steady for both of us. Petra called the following week and apologized without quite naming what she was apologizing for, which told me she understood more than she was willing to say. Aunt B sent a card this time, with actual words inside. Uncle Noel, who had stopped meeting my eyes at gatherings, called to ask if I needed anything. I told him I was fine. The people who had quietly accepted Damien's picture of me as fragile were now quietly revising it. Not loudly. Not with grand gestures. The way people revise things they should never have believed, in private with a certain amount of shame. Stuart, at a small Sunday gathering at Miriam's house, stood beside me in the kitchen and said simply, "I told them what I saw." It was enough. I moved out of the house on Caldwell Drive on a Thursday. I did not need a moving truck. A few boxes of books. My records. The pin I had worn to the hearing, which I placed carefully in a velvet case. Priya filed the separation petition that same week. The process was quiet and structured. Under the estate ruling, my marital interest in the assets was protected. The original trust structure was restored. My share, the share Bernard had always intended to exist, was formally recognized. There was no final confrontation. No dramatic scene. Damien sent one message through Baton asking whether there was room for discussion about an alternative arrangement. Priya responded in 2 sentences. There was not. I found a small apartment on a street lined with old trees. The light came through well in the mornings. It was a different kind of quiet from the house on Caldwell Drive. Not the heavy silence of a marriage where things go unsaid, but the clean quiet of a space that is simply, honestly, yours. I set the boxes down. Made tea. Stood at the window. It didn't feel like victory. It felt more like accuracy. Like the record had been corrected. Like the truth had finally caught up to what actually happened. 4 months later, I registered a small foundation. I named it the Archer Stewardship Foundation, after Bernard, after the word he had used in his letter, after the idea that some things are worth preserving carefully and without credit. Its purpose was to offer free financial literacy guidance and estate planning resources to women navigating inherited assets alone. Women quietly managing documents and accounts for families that did not always see what that work required. Miriam contributed the first donation without being asked. Dorothea, who had witnessed Bernard's letter, agreed to sit on the advisory board. She accepted with 2 sentences and a handshake. Stuart offered his services on a pro bono basis for the first year. He showed up to the first planning meeting with a folder and practical suggestions that turned out to be genuinely useful. The foundation's first event was a Saturday morning session in a community center near my apartment. 14 women attended. Several were navigating estate situations similar to mine. I didn't tell them my full story. I told them what I had learned. Keep every record. Date everything. Know the documents better than anyone else in the room. And never let anyone mistake your silence for surrender. The last I heard of Damien came through Nora. She called one evening, her voice neutral the way it gets when delivering facts rather than opinions. The ethics review body had concluded its assessment. The finding was not criminal, but it was formal and recorded. Damien had appeared before the panel. 2 significant clients had stepped back from his consulting firm in the months following the hearing. Quietly, the way clients do when a name appears in legal news they would rather not be near. Colette and Damien had separated before the baby was born. Nora offered no further details. I thanked her. Then I asked about her children, her garden, whether she had traveled recently. We talked another 20 minutes about things that had nothing to do with any of it. When I hung up, I sat in the morning light of my apartment and thought about Bernard. He had written, "Let the record show what this family was built on, and who kept it standing when it was hardest to do so." I had kept the records. Completely. Not for recognition because it was simply the right thing to do. The record showed exactly that. His integrity had built something. My patience had protected it. In the end, the truth needed nothing else.